Good afternoon, everyone. Thank you very much for joining this virtual event, this webinar about applications to the Criminal Injuries Compensation Authority. We've had a fantastic response to this, so I wanted to say a warm welcome and thank you very much for all coming to join us this afternoon. A little bit about the purpose of the webinar is to bring together as many people as possible that are working with victims of crimes of violence in different ways, and to give everybody a bit of an understanding of how this scheme works, how the applications work, so that you can take that information and that knowledge back into your own work when you're working with victims of crimes of violence. We know there's a lack of awareness about this scheme because we've had that fed back to us, so it's really good that we've been able to do this with so many people, so that we can bring some awareness of the scheme to everybody. Just to explain a little bit about ourselves and the two presenters that you've got this afternoon. First presenter is myself, Sarah Brumpton. I am a solicitor, associate solicitor in the serious injury team at Irwin Mitchell. I've been at Irwin Mitchell for 25 years and I've always done CICA work as part of my practice. So I've been dealing with it a long time, and I've been through a lot of cases, a lot of changes to the scheme. I'm joined today by my colleague Sam Burnard, who is also an expert in CICA cases, and she joined us recently from another firm where she's developed a good expertise on lots of issues involving the CICA. So together we are a team of 5. We run all our cases nationally for Irwin Mitchell from our Leeds office. We deal with all types of criminal injuries compensation claims. So we tend not to turn anything away unless it's something we really can't accept. Just a couple of housekeeping points. This seminar is designed to last about 40 to 45 minutes, which is the time we'll talk for. After that, we're going to leave some time for questions. But as regards questions, we invite you to ask questions as we go along using the Q&A function on your toolbar. And what we'll try and do is deal with those questions in the course of the seminar, but if we haven't been able to do that, we'll deal with them at the end. So hopefully we'll be able to answer your questions as we go along through the slides. After this webinar, the recording of it will be sent out to you, everybody who was on the list, so you'll get a recording of this so you can watch it again at your leisure or share it with other people. We can send that out. One final matter of housekeeping. Please can you complete the feedback form, which will be sent to you as you're watching and also at the end. So that's been really helpful to us, so we can work out what you've enjoyed about this and what we could do again if we do this again. Final points, I'm at home, so as everybody is at the moment, so I apologise now for any dogs barking or anything like that happens as we go along. So just going to our first slide, which is really a bit of a background introduction to the CICA scheme. So it's the Criminal Injuries Compensation Authority, which everybody probably knows, and it was brought in, it's a government scheme brought in the early 60s to compensate for innocent victims of crimes of violence. Nothing is covered pre-1964, but we don't get too many inquiries dating back that far, although we do have some. It's not an insurance, and there's no insurer involved in this. This is a government scheme paid out by government funds. And they're based in Glasgow, and it's a scheme run by civil servants. So decisions are made by civil servants in the course of the scheme. Sometimes that can be a bit controversial, but it is run by civil servants and it's part of the Ministry of Justice. They pay compensation. Sometimes that can be a bit of a misdescription because compensation can often be disappointingly low in the CICA scheme and can be disappointing to applicants. So sometimes the word compensation is a bit misleading to people. It doesn't always put them in the position they were in before. So the current scheme was brought in on 27th of November 2012. Prior to that, there were changes to it in 1996, 2001 and 2008. The 2012 scheme was brought in because basically it was costing quite a lot of money and changes needed to be made to cut down the cost. So the current scheme is probably one of the least generous of the schemes that have been introduced. Recently, there was a report by the previous victim commissioner, Baroness Newlove, who called for an overhaul of the scheme because it was long overdue. There were issues with the scheme being re-traumatizing for victims and triggering trauma, and so she called for this to be reviewed. That was going to lead to a review by the Ministry of Justice, but that's kind of been kicked into the long grass with Brexit and other issues that have come up. So it is a long overdue for an overhaul, and it needs to be more generous to victims. Recently, there's been a change. They do some changes sometimes when things seem to be very unfair. A recent change is to the same roof rule. And this rule said that if a person was abused by a member of their own household prior to 1979, they weren't entitled to any compensation. And the reason behind that was to prevent anybody in the same household benefiting from any award. Clearly, that was very unfair to people. When they say people in their own household, that was parents or foster carers. But that was recently changed so that now people can put in claims for abuse that occurred pre-1979 under the same roof as the perpetrator. There's a temporary change to this, so claims need to go in, and we've had some coming in where we've been able to get some results for people who were previously barred from claiming. There have been other controversies with the scheme. There was an issue of consent in sexual offences involving underage children, so that's also resulted in some changes. We just move on to the next slide, which tells us a little bit about who can claim under the scheme. Adults and children can claim. I mention children because we do a lot of work with children to get them access to compensation. We have quite a few cases which we run, which are shaken baby cases, where we get instructions from local authority or social workers to act on behalf of children who are with foster carers or have been adopted but sustained quite serious injuries as babies. The other requirement in order to claim is the second point on the slide, which is they must be ordinarily resident in England, Scotland or Wales. And the ordinarily resident requirement is quite strict and it's quite difficult. So you have to be a British citizen or fall into the categories that they list as being ordinarily resident. So this can include people who are seeking asylum, made an application for asylum, or who have been referred to a competent authority, such as the National Crime Agency, as being a victim of human trafficking. That would let them in under the ordinarily resident requirement. A relative of a UK citizen can claim, but what I'm saying about this is it's quite a difficult test. Every claim has to be judged on its own facts. There's no hard and fast rule on this, and there are some nuances within that rule and some areas which are tricky. So really, advice needs to be taken about whether a person can claim and are they ordinarily resident. We've had some appeals on that point itself. An EU citizen who is visiting the country can claim under our scheme. A UK citizen visiting an EU country would have to claim under that EU country's scheme themselves, and that might all be thrown into doubt when Brexit comes in. Secondary victims I've mentioned on the slide. They are somebody who had to be a close relative, or have a close relationship of love and affection with the person that's been injured, and they would have to be either a direct witness or be in the immediate aftermath. So there's quite strict requirements for secondary victims, although they can claim. So somebody who's witness to an assault or some violent crime can claim. Another category of claimant who we've not raised on the slide is in a fatal claim. A qualifying relative can claim where a relative has lost their life, and that qualifying relative can be a spouse or partner, a parent or child, but we are going to go into that in a little bit more detail as we go on with the presentation. Once you've established ordinarily resident and that you can claim, we move on to the next slide, that tells us a little bit more about what happens on the next eligibility consideration. I'm just going to hand you over to my colleague Sam Burnard to go through the eligibility considerations with you.
Thanks, Sarah. Yes, I just want to go through some eligibility criteria. I know we've had a few questions about sort of length of time of claim, also things about factors involving the police and how they can help applicants during the process. So the first thing to be aware of, a person claiming has to be a victim of what the CICA feel is a crime of violence. So under the scheme, that can involve things like direct assault, direct abuse, sometimes indirect incidents. So I've had cases before where somebody may have been in a bar, for example, and a fight's broken out and they've been hit randomly. Quite often they may not know the person who has been the assailant. Also covers fatal incidents, as Sarah's already mentioned, and also incidents where somebody may be under threat of immediate harm. There are a couple of exclusions to the crime of violence, specifically in relation to something involving a vehicle or a road incident. So the CICA scheme is quite specific in that you have to be a victim where a vehicle's been used deliberately, it's so intentionally used as a weapon. Similarly, we also have incidents in quite a lot of queries involving situations where somebody may have been bitten by a dog, and that again can be quite tricky in terms of going through as a successful claim. Main reason being is the dog also has to be ordered to attack somebody, and so if you have a completely random attack, CICA tend not to cover that. Conduct and character is also something the CICA will look into. So for example, if a person has been involved in a one-on-one fight, or they may have responded in a disproportionate way to somebody threatening them, it can sometimes lead to the CICA making a reduction to compensation, or they may, in worst case scenario, reject the claim as well. Cooperation with the police is also really important. As far as reporting is concerned, usually as soon as possible is the advice that we would give. The scheme tends to say they would expect a report to be made within 48 hours. It's not always possible for that to happen, and there are sometimes considerations given to exceptional circumstances if there is a delay in reporting, without a really good reason why. Quite often, again, the CICA are very strict and they will reject a claim. So what we'd probably touch upon in terms of the police helping victims throughout the process would be just to generally make them aware of any help and support that they have available to them. And quite often, if a person withdraws a statement or doesn't want to go to court, we find that will also have a negative impact on the outcome of the case. As far as not wanting to proceed to court is concerned, if a person's afraid of repercussion, the CICA don't accept that as being a justifiable reason. It can be slightly different if a case isn't able to go to court for the reason that the police or CPS advise against it. In that situation, the CICA will consider a person to have cooperated as reasonably as possible, and we would still encourage a claim to be made. The fact that something doesn't go to court doesn't necessarily mean that a person can't claim at all. Convictions checks are also carried out as standard under the scheme. So again, the CICA have extremely strict rules and guidelines regarding that. What tends to happen is they'll do a standard check on every applicant that applies. If something comes back that's an unspent custodial conviction, it usually results in an automatic rejection, and that applies to anything before or during the course of the claim. If somebody has a clean record before they put a claim in, but then commit an offence later on, it's likely that a case would be rejected as well. There are some exceptions to that, so things like driving offences and fines might be subject to a reduction in compensation, but the general rule would be if you have a conviction, we'd advise either to wait until that's become spent to claim, provided that that is in the time frame that you have to claim. If you wait and then apply and the delay is the reason for the conviction wasn't spent, it's still unlikely that a claim would go ahead. So if I move on to the next slide, I just also want to talk about time limits. So the usual process for a claim would be a person has 2 years from the date of an incident within which to claim. But there are some exceptions to that. So generally speaking, if a case has happened where a person is under 18 and a report was made to the police at that stage, the 2-year time limit would apply from the date of that person's 18th birthday. So you do have a bit more leeway if you were a victim as a child. Slight variation on that would be if a person was under 18 but it was never reported to the police. If a person later approaches the police as an adult, the 2-year time limit would also apply from the date of the report that's been made. So that's quite different to if there's a delay in claiming, for example. So it's normally in cases quite often where victims of abuse find it quite hard to come forward. So the CICA are a bit more lenient in that respect. As far as making claims out of time are concerned, the CICA will consider exceptional reasons to waive the time limit in any event. Again, it's dealt with on a case-by-case basis. So, for example, if somebody lacks capacity and they can't conduct their own claim, or they may have specific life and personal circumstances or other medical circumstances that have meant they've not been able to claim up until that stage. So from that point of view, it's always worth looking at things in a bit more detail, just to see if there's grounds to persuade the CICA to accept a case out of time. And if we move on to the next slide, I'll just pass you back on to Sarah.
Just to pick up on that last point, Sam, about the lacking capacity, sometimes we do have situations where somebody might have been in hospital for 6 months, and that would count as a period of time where they wouldn't have been able to claim. So if there was 6 months plus 2 years, then that 6 months probably wouldn't be taken into account. So there are variations on it, and we would always say seek advice on that point, because there's very often that we can get people into the scheme, get a way around it. Just moving on to what type of awards can be made. The CICA operate on a tariff award scheme, which is a fixed tariff of injuries, basically a list of injuries and what you're entitled to if you in whatever category you are in. And they're a bit disappointingly low on some aspects. It's rather crude. A lot of the time it's based on recovery and injuries and recovery, really. Some minor injuries are completely out of the scheme totally. That was 2012. Some were out very minor injuries. It can be quite complex working out what you're entitled to in terms of an award, especially in things like traumatic brain injury or psychological injury. And when I talked about them being a bit disappointingly low, on a case where you have the most severe psychological injury, a permanent PTSD affecting all aspects of life, the tariff award is only £27,000. So that's very low, really, for what somebody would be a sort of life-changing situation that they're in. So on brain injuries, for example, they can range from minor brain injury up to, which can be sort of £6,000, up to most severe brain injury, which is £250,000. And in there's a range of brain injuries. So it's quite important on brain injury claims to make sure that people have advice so that they can get to the right level of award within the brain injury awards. There is a moderate, there's a significant, there's minor, there's all sorts of levels, and often medical evidence is needed to get to the right level. Since 1996, the maximum award has been £500,000, so we can never go above that, which seems like a lot, but it's not really. In the most severe cases, we do sometimes even struggle to get to that level. And it's not a lot in those cases, and that is why it's so important for us to make sure that people have advice and get to the maximum they can. the scheme actually is just, I should have mentioned before, is actually designed for people to do the claims on their own. That is something that people can do. We do often get people coming to us when they've done that and said, oh, I've got this award, doesn't seem very much, or I've been told that it's not enough and I should seek advice. So we do get people who come to us when they've been given a low award. The awards are available for psychological injuries, obviously, because they're an injury as well. They can be tricky too, because I think we had a question on this, which was how do we evidence psychological injuries in victims of human trafficking? So for psychological injuries, there would need to be some sort of diagnosis. Somebody would have needed to be gone to the GP, had treatment, had some sort of diagnosis of a psychological condition, PTSD or something like that. Without a diagnosis and without going to the GP, then the CICA can find that difficult to make an award. And there are good reasons why people sometimes don't go to the GP with psychological injuries. We're dealing with a few cases from Manchester Arena, and some of the children there haven't been to the GP because for very good reason, and their families haven't felt that's appropriate. And we're having some difficulties with those. Or where we've got historical abuse cases where people have buried memories of what happened and don't want to discuss it and haven't been to the GP but clearly do suffer. So we would look at trying to evidence those in other ways. On the fatal awards, it's not in the slide, but just to mention to you that in terms of the fatality, the qualifying relative, which I mentioned before, can claim a bereavement award, which is a small amount of money, funeral expenses. If there are children, we can claim a loss of parental services, and if children or spouse or partner were financially dependent on the person who's died, then we can claim a dependency award. And they're quite complicated cases, so advice is needed for a fatal claim. In terms of psychological and injuries and sexual abuse, the CICA don't compensate for both in that way, so it's whatever is higher. There is a tariff for sexual abuse, and there's a tariff for psychological. So if somebody suffered sexual abuse but then has psychologically affected, we would really look at which was the higher award really, and put in for that. The CICA won't award for both. And just on that point, the CICA, if there's more than one injury, they don't award those three. If they say there's 3 injuries, they don't award those in full. You get 100% of the first award of the first injury, which is the most severe, only 30% of the second, and 15% of the third. So where there's multiple injuries, it's not 100% recovery on all those. And just my point about the awards depending on the level of severity of injuries. For example, a very serious brain injury where somebody makes a really good recovery would be on the sort of lower end of the scale of brain injuries. It's about the recovery really. I'm just moving on to the next slide, which gives us a little bit more information about what other awards the CICA can make. Tariff is one thing, and that's kind of an award for the injury itself, but they can award for other financial expenses. So loss of earnings does come under the scheme. It's quite restrictive under the 2012 scheme. You would have to show that you have been unable to work for 28 weeks or longer. You'd have to show that you've got a good working history or a good reason why there isn't one, for example, have been studying or something like that. And then also the awards don't really reflect the earnings that you've lost. So whatever job you were doing, whatever you're getting paid, the CICA only pay out at a flat rate of SSP. So they don't take into account what people are doing for them. And people can find that very disappointing that they've lost a lot of earnings and really CICA paying fairly basic award. But it is there, and it's there to be claimed, and we do make sure that people do that. If you're entitled to loss of earnings, that kind of opens the door to special expenses, which is things like the cost of care provided by a relative, which could be quite significant where somebody's quite severely injured. The cost of buying aids and equipment, wheelchairs or walking frames, things like that, and also the cost of adapting existing accommodation, putting in extra rooms or a wet room or something like that. What they won't pay for is purchasing another house, so they don't pay for a new home, and what they also won't pay for is private treatment. That's not an element of the claim that we can make. If a person lacks capacity to make decisions or manage an award, then we would need to involve the Court of Protection to protect them as vulnerable people, and the Court of Protection would need to appoint somebody to act on their behalf. Fees are involved in that, but the CICA will pay for Court of Protection fees. On this slide, I've also mentioned about benefits deductions. The CICA won't deduct loss of earnings benefits such as ESA, but they will deduct things like DLA or personal independence payments from care awards, so those benefits can be taken into account. But what we do suggest to clients where there's a care claim on benefits is that their award goes into a personal injury trust at the end, and that would ring fence their award and would prevent them from losing any means tested benefits after the award is paid. And that's really important that people have that advice so that they don't lose their very precious benefits that they're getting. And that does work. We can put it into a trust, and it's something that does happen with a lot of our clients. Just passing you back on to Sam now to go through the next slide, please.
Thanks, Sarah.
On medical evidence.
Yes, I'm going to just briefly cover and pick up a bit on what Sarah's already mentioned about medical evidence to support injuries. So as a standard part of the process, the CICA would usually specify that it's the responsibility of an applicant to prove their case, essentially. So the CICA tend to not really prompt for information unless they feel it's necessary for their assessment and their inquiries. As far as requesting medical information is concerned, they will issue requests for things like records or reports from treating practitioners. It's important to note with the initial medical report, it's normally likely to come from somebody's GP, and it will also require an applicant to be responsible for the initial cost, so that's usually capped at a maximum of £50. If it's the case somebody can't afford that £50, the CICA can agree to cover the fee, but it's likely that they will deduct that from an award of compensation at the end of the claim process. As far as that's concerned, when we deal with these sorts of issues with a claim, at the moment we basically agree to cover the cost of the initial report. Any further records or updated reports will normally be paid for by the CICA. So you'll tend to see that there's a report with very specific questions to medical people to fill in. Sometimes they ask for opinion on capacity. Just referring to a couple of queries we've had about evidencing medical issues if a person's not actually been able to have treatment themselves. So again, we appreciate in some instances, Sarah's mentioned already, in cases of abuse, for example, people quite often don't like to discuss what's happened to them, and that in itself can make it quite difficult to show things like psychological injury. So there's a couple of ways around that issue. One would be to consider obtaining a medical expert's report yourself, so that in itself can be quite expensive. In some instances the CICA will look at an expert's report if an applicant's provided that, but there's no guarantee that they will reimburse the cost of the report. Another alternative would be to maybe try and get some supporting letters from a GP. If a person's had a delay in seeking treatment, we'd always encourage that person to try and seek treatment as soon as they possibly can. Sometimes the CICA need a little bit of spoon feeding, in my opinion. So if a person's having ongoing treatment, it's always really important to make sure that they're aware of what's going on, in which case they usually will come back to an applicant to ask for an update on that treatment and just essentially make sure that they have all the correct and up-to-date information to assess. A final thing that can be requested from the CICA would be for them to arrange a medical assessment themselves. So they tend to refer to that as what they call a special medical assessment. But again, this will be at their discretion, so it's not always guaranteed that they'll move forward and agree to that. But so from that perspective, it's always advisable to just make sure you have all your medical evidence ready, explain all your symptoms, all your injuries to the CICA, and they'll make further inquiries that they feel are necessary from that point. So if I'll just move on next, I'm also going to just briefly cover the application process as a whole overall. I know we've had a question about how long cases can take. On average, as a minimum, they can approximately take around 18 months up to 2 years, but this can vary depending on the extent and the nature of somebody's injuries, and it also refers to effectively how long the CICA can take. Their overall process is very, very slow at the best of times, and we've noticed recently with the impact of COVID-19, it's likely to take even longer at the moment as well. So the initial stage of the process, there's effectively 3 main stages. So first of all, the first part would involve submitting an application form online to the CICA. Once that's registered, they begin making their own inquiries. So the first thing they'll do is usually write to the police with a request for information, and police officers who are joining us today will probably be aware that it's normally a report that they're asked to complete. From that perspective, we'd always say to complete it with as much information as you can, especially if there's any significant information in relation to things like a delay in claiming or a delay in reporting. Quite often some victims will be advised not to claim until the outcome of court proceedings are known, and if the CICA are made aware of that, they will take that into account as an exceptional circumstance in terms of time limit. Once the CICA have received all the police evidence they need, they will move on to obtain medical evidence as well. As I've mentioned before, usually will involve reports and records if required, and any other information that might be relevant. If somebody's claiming special expenses, for example, they may want an applicant to provide information to support loss of earnings. Once all that information's been assessed, a first decision will then be made. Usually it will be the case it's either an award or a decision to reject the claim for some reason. If a person is happy with an offer that's made, they have the option to accept it at that stage. If they disagree with the offer or the reason for a rejection, there's an opportunity to move on to the second stage, which would be to apply for review. So you normally have 56 days within which to submit the review application to the CICA. The date for that's normally specified in their letter. Once a review application is made, someone completely different at the CICA will assess the review. The application normally should include reasons and grounds for review. If there's any other supporting evidence to provide, that should also be included. It may be the case the CICA feel it's necessary to make further inquiries of their own and get some more up-to-date evidence, and that will go through the whole assessment process again, with a review decision being made. So again, this could be a further offer or it may be a rejection again. From that perspective, an applicant again has the option to accept a review offer if they're happy to do so. Alternatively, you'd then be looking at the third and normally the final stage of the claim, which would be to go to an appeal tribunal. So this would involve completing a notice of appeal, and the deadline for that's normally within 90 days of a review decision. From that perspective, it goes to the CICA tribunal, who are an independent panel who hear the claim. Usually we'll have something where you're heard as an oral hearing or a telephone hearing, which we're finding is more common at the moment in the current situation. Panel's normally made up of 3 people, so there's usually a tribunal judge, a layperson and a medical expert. They normally will hear all the evidence based on the grounds for appeal. And once a decision is made, if it's in relation to an award, that decision would normally be final, and then the person would basically be looking to accept that. If the decision relates to a point on eligibility, it's important to note that that point alone will be considered by the tribunal. So once that's been agreed, it will then be passed back to the CICA for further assessment in relation to an award. So it effectively resets the whole process, and you'd end up in a situation where you have an initial decision again, followed by a review and potentially an appeal again, if it got that far. And it's always really important to note as well, with any review or appeal that's made, decisions can change. So if an award is made, there's a risk that it may decrease as well as increase, or it may also just be kept the same. So from that point of view, it's always worth weighing up the pros and cons with an applicant, and just to see whether there's something there where further compensation may be achievable. And with that, I'm just going to pass you back to Sarah, just with some other important factors to consider regarding the claim process.
So we've called this other help and assistance, but really it's just to sort of cover off a few points. Just one question that's come up, which I can deal with fairly quickly. Somebody asked if the £500,000 was to include the loss of earnings and special expenses. It is. It's a cap on the whole thing. You can never be awarded more than that, including tariff, loss of earnings, and care, specialist equipment, and those elements of the claim. So also to cover off a few questions we've had regarding civil and CICA cases running at the same time. So can you run a CICA and a civil case together? And that would be something like a civil case maybe against an institution arising from abuse, against an individual assailant themselves personally, or a deliberate running over. That might result, a deliberate running over could result in a road traffic claim as well. If that happened on a road, that can also be an insurance claim as well. So the answer to that is yes, you can run those together. You have to be careful about the time limits. We've obviously said two years with CICA, different time limits on civil cases, so that has to be taken into consideration. You can run them together, and we would always say do that. So start 2 claims off. Don't wait for the outcome of the civil case before running a CICA case. Run them together to cover all the bases basically. And so what might happen is the CICA might say, we'll ask on the form, is there another case ongoing? And you'd have to tell them that there is another one, and they might stay the CICA application until that civil case has been resolved. But they might not, if there's good reason to run the CICA case. For example, if the civil case is difficult, there are issues on liability, it may be that you want to see the CICA case through and get the payout. You can't recover twice. So in the event of getting a CICA award and then subsequently a civil award, you would have to repay the CICA what they've paid out. But we would always say do both, because CICA can be quicker and an access to some funds if needed, if desperately needed. One of the questions we've had, I hope that answers that. One of the questions we've had is about what about a serious injury and a fatal road traffic collision, where there's does a CICA apply? And I think the answer to that is if it's a road traffic collision, the key word is collision. There's no crime of violence, so there has to be a crime of violence for the CICA to consider anything. So if a car is used in deliberately running somebody over, that is the only circumstances that we would look at a CICA case. And there might also be a civil case there as well, so we'd look at both. But it would have to be a crime of violence, some deliberate element of running somebody over or using the vehicle as a weapon, as we've discussed. So that's really about the CICA and civil cases, I would invite people to contact us and more, because it is quite a complicated area, and be a bit careful about running the 2 cases and the time limits. So I'd seek advice on those. The CICA won't fund rehabilitation and treatment. That would have to be paid for by the applicant themselves. They don't cover that. What they will pay sometimes is an interim payment. It's not set in the scheme, but they have discretion on interim payments, so that if you've made an application and eligibility seems to be fine, they sometimes can consider an interim payment, which would be really useful for people to fund some treatment, or if there's financial difficulties, are not working or need a piece of equipment, or just to make sure that they can stay in their own home if having trouble meeting mortgage payments. So we find that they really come in useful for a lot of people, but they do have to be taken into consideration at the end, and we have to be careful about benefits. But interim payments are available, and the CICA don't really make that well known to people. They do exist. Help and other help and assistance. We're very fortunate at Irwin Mitchell to have the benefit of client liaison managers. Some I know are watching this presentation, and they are each of our offices has a client liaison manager. They're usually qualified OTs or people who work with in the sort of healthcare sector, and they can help our clients with accessing benefits or accessing support in local communities, challenging local authority decisions, such as making sure that people are getting exactly what they're entitled to in terms of help and support from a local authority, or just really to give emotional support, and to support and guide people, and to be there for somebody in difficult circumstances where their life has changed, to feel like they've got somebody on their side who's fighting their corner. And recently our client liaison managers have been doing a lot with telephone advice to our clients, some of whom have been struggling with the recent lockdown and disabilities and struggling with mental health. So they've been doing sterling work recently. So very fortunate to have those. We don't charge for the work they do. They can assist clients throughout the case as and when needed. We have other departments where we do refer on. Just to mention, we do sometimes take legal challenges to the CIC. For example, on a matter of a crime of violence, if we think that they've ruled a case out because it's not a crime of violence, we can challenge that, and we are doing that on some human trafficking cases where they're saying that's not a crime of violence, there's no actual violence involved, and that can cover things like grooming and where there's no actual violent act. But what we've challenged is the fact that they are crimes and there's an injury, and that's not the purpose of the scheme. So we have a public law department who can take on those sorts of legal challenges to the scheme, and they come in really useful. Also legal challenges to local authorities who might not be providing the correct amount of support. Our court of protection team exists to help our vulnerable clients with issues of money, to protect them, to make sure that they're not exploited and that their money is looked after and invested for their protection. And we have a trusts and powers of attorney department who can help with trusts. If we're dealing with a shaken baby case, the award has to go into a trust to prevent any of the perpetrator's benefiting. So a trust is set up in those circumstances, and we do have a trust department. We do have a family department who can help our clients in different ways. We recently had a claim for a child who'd been assaulted by his father as a baby. The father had a bungalow. We managed to get an award under the Children Act to force a sale of the bungalow and for him to contribute towards the care of the child. So fortunately, we do have that ability to be able to refer on to other departments and support clients in that way. So just to go on to the next slide, which is other considerations that we need to think about. I think I've already made it clear that CICA awards are lower than other types of compensation awards, and I think really it's more of a gesture of goodwill rather than compensation. They do tend to be quite disappointing to people. I wanted to mention about reopening cases, because we do get people coming to us quite fairly regularly and saying that they had a case, we only got this amount of money and now they're struggling. So you can reopen cases. If you have to show that there's been a significant medical deterioration in injuries, if we can show that and provide proof, medical proof that somebody has had a deterioration, then we can write to the CICA if we've got the reference number and ask them to reopen. It's simply a question of a letter, and they do reopen cases. And if they do reopen the case, it will be judged on the scheme that it was made upon in the first place. And we've reopened cases going quite a long way back. I'm recently looking at reopening one from 1998. So we're open to looking at reopening cases. That's something we do if somebody's acted on their own behalf and not had legal representation and felt that things have deteriorated, then we can look at reopening for them. Quarter protection, and in terms of lack of capacity, we get people who lack capacity and quite severely injured. They do actually need a quarter protection order before we start a claim now. So we get quarter protection involved early on to get the necessary order for that person to bring a claim to the CICA. Can result in a bit of delay, that, but we do have to do that now. It is a requirement. Children awards are usually kept by the CICA in a retained award scheme, so they don't have access to it until they're 18, except for little things that they can apply for equipment or laptops. Or there is an exception to that, and that is on a shaken baby case where the award would go into a trust, and actually the child can get access to that via the trustees during their childhood. So it's not always the case that it's kept by the CICA until 18. Finally, the judicial review of a decision is what I mentioned earlier about challenging a decision made by the CICA. If we think it's not correct in law, been some mistake made, misinterpretation of the scheme, we can judicially review. It's a public law matter. There is a strict 3-month time limit. So if anybody's had a decision which they think was actually wrong in law, not in terms of the award, but actually made a mistake's been made, then there is a strict time limit on that of 3 months. We can refer those on to our public law team. We're doing those on human trafficking cases, reviewing whether it was right to say they were not victims of a crime of violence. So judicial review is something that we do take on. I think now that one last point on funding, because I think somebody sent a question in about funding. How are these cases funded? There's no legal aid for these types of award, and what we do is a no-win, no-fee agreement where we'd only charge if we get an award, and most solicitors will do it on that basis. It's the only way we can do it. So that's the way that these cases are funded. If anybody wants any more information about funding of cases, we can do that separately, but it wasn't really our intention on this webinar to deal in detail with funding, but just to touch on it to explain that that is how these cases are funded. So I think that leaves us 10 minutes or so to have a look at some of the questions. Are there any questions that you want to take, Sam, that you can deal with?
I can, yeah. I think I can just address. There's been a few about the things in relation to sort of abuse cases and things like that. So we've had one question asking whether post-traumatic stress disorder is a psychological injury. So the very short answer to that would be yes, it is. So usually for the CICA to look at that, there has to be, Sarah mentioned earlier, details regarding a psychological diagnosis. So it usually has to be from somebody quite highly qualified, like a psychiatrist or clinical psychologist. But yes, that would be something that would be considered as a mental injury under the scheme. There's also been a query regarding if somebody has a compensation award from court proceedings. So that kind of goes back to what we've mentioned already about claiming twice for the same incident. So the CICA usually would need to be made aware that there's been a separate award from court proceedings. What they'll do is take it into account when they make their assessment. Sometimes you might find they'll keep a case on hold pending the outcome of any other court compensation decision. It's quite important to note that the amount that somebody might receive or be awarded, that the whole sum will be taken into account. So even if somebody received half of an amount, the CICA at the moment are actually offsetting the entire sum. So you may find that the CICA would, in effect not pay anything at all if that award for court compensation amounts to more than what they might assess. And I think just going back to sort of the overall timescale as well, I think I did see a question about if something can be done if there's a fairly simple claim that's taken longer than 2 years. I think that the sort of brief answer to that would be just basically keep chasing the CICA. So they will tend to sort of deal with things in quite a strict date order usually, but there is scope to sort of raise complaints if it's become an excessive amount of time. So that's what I would probably suggest from that point of view, that there's not really any sort of set way you can kind of hurry a claim through. Quite often we do find it as a bit of a waiting game, unfortunately.
There's one question that we had. It said, are the applications viewed in isolation of any other awards, such as from the London Emergencies Trust or charitable donation, where crowdfunded? The answer to that, as far as I'm aware, is no. Is yes. They can still be a CICA claim, even though somebody's had a payout from one of these charities. But it is up to the CICA, and they would have to ask them whether they were prepared to pay out, even though there had already been a payout from a charity. But my view on that would be apply and ask, and that you would have to show that you had an award from another source. But we have had cases where they have let these go through and had a CICA award and ignored anything that's been paid under the any charitable fund arising from that incident. Another question was about the Italian compensation scheme for sexual violence. I wonder, Sam, do you know anything about the Italian scheme? I would say you've got to look at the scheme in the country where the incident happened. We can't do anything in this country.
I think there are some European countries that may not necessarily have a compensation scheme of their own. I may be wrong, but I think Italy might be one of those countries which doesn't. You've got sort of countries like France and Spain and the Netherlands, they definitely do. But it's always worth sort of having a chat with CICA, so they have a specific department which liaises with other countries who deal with the claims abroad. So they might be able to advise more clearly on which countries do have a compensation scheme that's in place.
Another question we've had: at what point would you ask a solicitor to assist with a case rather than managing it as a support worker? Right at the beginning is the answer to that, because we have to be careful on an issue such as spent convictions. So if you run a case for somebody, you need to be careful that you're not putting the application in while they've got unspent convictions, because that would result in it being rejected and they wouldn't be able to put another claim in. So in some cases we do a police national computer check before we put the application in, to check that people's convictions are spent, because people tend not to be able to remember when things happen, when they were convicted. But you've only got one go at it, so you need to be careful about putting applications in with somebody who might have convictions in the past, because that can lead to them being rejected. Another question is, if a case reaches a criminal court and a verdict of not guilty is given, does this affect the CICA claim? The re-eligibility requirements are the same regardless of what happens with the criminal proceedings. We can run cases where there's no criminal proceedings or not guilty, but we still have to prove that it's a crime of violence, and it's a different burden of proof for CICA. It's on the balance of probabilities, whereas a criminal case is beyond reasonable doubt. So we've got a lower burden of proof. It might be easier for us to prove in the CICA that a crime of violence did take place, even though a criminal case has failed. Working with children and young people, if it appeared they were eligible, would seeking legal advice in the first instance be advisable than supporting them to make that initial application? I think yes, it's always advisable to take legal advice, because of the points I've mentioned before about spent convictions. That's just one aspect of it, but just to make sure that the application is going in properly and that the person involved is getting the help and support that they need. We would make sure that they are getting the right advice and support when we do the applications for them. We've had a question about working with victims of sexual violence. Clarity on PTSD. Is this a psychological injury? Yes, absolutely. It's a psychological injury. It's one of the most frequent we deal with. Can have a massive impact on a person's life. And PTSD, they do make awards for depression, anxiety, all the sort of psychological injuries are covered. So it definitely PTSD is a psychological injury that's covered in the scheme. Sam, would you be able to deal with this, please? Can I confirm the victim reports childhood abuse as an adult?
Yeah, so yeah, basically yes. So if a person's been victim of abuse as a child and they first report it to the police when they're an adult, then yeah, the 2-year time limit would run from the date of the report being made. So it's a bit different to considerations for delay in reporting. So general delay in reporting situation might be somebody that say been assaulted, and then the kind of waited to see how serious the injury was for a few days. So if unless there's been a very specific serious injury for delay, the CICA would kind of take a negative view on that, but with childhood abuse it's quite different. So from that point of view, if they have never reported it at all, it would be 2 years from the date of reporting to the police.
Okay, and then we've had a question, can you reopen in a case even if they've received a maximum award? Yes, that's a tricky one, because normally we're reopening cases to achieve higher awards, but we do have some cases where it's been calculated not in the correct way. It depends on why you want to have the case reopened, but the answer is potentially yes. We'd have to make see how that actually needs to be reopened and why that is. And then there's a question here. Have you dealt with this about complaints? Yeah,
so I think just to clarify a bit more on that, the best way to complain would be to put something in writing, and they should make a sort of acknowledgement response to that, and it can be escalated if necessary as well.
Okay, I'm really sorry. We're actually running out of time, so I'm sorry if we've not been able to deal with the questions that you've put. Please email those to us or ask them afterwards, and we can deal with those. Thank you very much for listening to what we've had to say this afternoon. I hope you found it interesting. Please go on to our coronavirus hub on im.com to look at the support that's being offered there. It's excellent. There's some really good stuff on there to help people, clients, and with the difficulties that people are experiencing at the moment. You can log on to previous webinars, sign up for new ones. I know later this month there's a webinar on dealing with spinal injury whilst in lockdown from a client, and also one about camouflage, skin camouflage surgery, which will be really interesting. We'd be interested to hear from you about any topics that you would like to be covered on these webinars, because we're quite happy to expand on anything we've touched on today and go into more detail. Once again, please can you complete the feedback survey in the Q&A box. It's really important for us to have feedback on these things, and thank you very much for listening. Please get in contact if you want to discuss anything further. You've got our emails. We're at home, we're dealing with emails. It's something we can do at the moment. Thank you very much.